All right, good afternoon. Welcome. We're going to go ahead and get started as a few folks are still joining us. My name is Sarah Gillooly, and I'm the Vice President of State Outreach and Engagement here at Americans United for Separation of Church and State. Every Tuesday in June at 3 p.m. Eastern or 12 p.m. out on the West Coast, we've been welcoming you each week and bringing you AU experts along with special guests from across the movement for separation of religion and government. And we are delighted to welcome you to our fourth of 5 installments. We've heard this summer from Rob Boston, who talked about the founding of this country and how religious freedom was embedded in the framers and the founders' understanding of who we are. We heard from Catherine Stewart, who talked to us about the rise of religious nationalism in this moment in her new book, The Power Worshippers. And then last week, we heard from Dr. Sabrina Dent and interfaith leaders from across the country as they thought about how their commitment to religious freedom and separation of religion and government is connected to their commitment to social justice. Today, we're going to be talking about the Supreme Court and the cases in the Supreme Court. And if you have read any news headlines over the last week, you know it is a wild time to be alive in this era of the Supreme Court. And another thing that's been really extraordinary about this term in the court has been the number of cases that deal explicitly with separation of religion and government. And so that's why I'm really excited today to introduce you to my colleagues, Patrick and Alex, who will be speaking in just a minute. Patrick is the Madison Legal Fellow here at Americans United, and he earned his JD from Harvard, where he was a member of the Criminal Justice Institute, as well as the Cyber Law Clinic at Harvard. Before he joined our team, he was a law clerk for a judge on the Texas Supreme Court, and also earned his bachelor's degree in both economics and psychology from Rutgers. He's going to be joined by Alex, who is the Stephen Gay Legal Fellow here at AU. Alex also earned his JD cum laude from Harvard Law School, and before that, he clerked for a judge in the U.S. District Court of the District of New Jersey and practiced as a litigation associate at the firm of Wilkie Farr and Gallagher. Alex earned his master's degree from Stanford, and prior to that, his bachelor's degree from Emory. So before I turn it over to Alex and Patrick, I have 2 quick notes for you this afternoon. First, I want to invite you back next week. We're going to be ending the summer series with our 5th installment next Tuesday, hearing from AU summer interns. These are some of the brightest college students, most passionate about separation of church and state, and they're going to be bringing us a discussion about how religious freedom, school vouchers, and disability justice intersect, and really expanding our understanding of some of the core issues around separation of church and state. That session next week will be closed captions as AU works to expand our accessibility. So if you or someone you know could benefit from closed captioning, we really encourage you to tune in next week. And then one last note for you before we get started is some technical features to make sure you have a great experience. First, you'll notice at the bottom of your screen, there's an icon that says chat and an icon that says Q&A. If you click on that chat icon, I'll be joining you in the chat box where we can you can talk back to us, we can interact. And then if you would like to ask a question of Alex and Patrick, you do so by clicking Q&A and then typing your question right in. Alex and Patrick are going to walk through the cases that are before the court right now, most of which we'll be hearing about literally in a matter of days from the court, if not the next couple of weeks. And after they talk to us about the cases, then we'll go to Q&A and we'll take our questions straight from that Q&A box. So be sure to drop them in. So without further ado, I'll be back to join you in about half an hour for our Q&A. I'm really excited to turn it over to AU Legal Fellows, Alex and Patrick. Take it away.
Okay, hello everyone. Like Sarah said, we have a bounty of church-state separation cases this term at the Supreme Court. And the only one that has a decision so far is the Title VII cases. So I'll start there. that came down just last week, and the Supreme Court said that the Title VII protections for discrimination because of sex extended to protect people against discrimination because of sexual orientation and gender identity. And that was actually 3 combined cases that all kind of came up at the same time. And this was maybe a rare win for our side at the current Supreme Court. And I'll just read a key quote from the opinion because I think it sums it up pretty well. This is Justice Gorsuch writing for the majority. It said, "The statute's message for these cases is simple and momentous. An individual's sexual orientation or gender identity is not relevant to employment decisions. That's because it is impossible to discriminate against a person for those reasons without discriminating against that individual based on sex." And I think that puts it pretty clearly. And he explained the logic of that reasoning. And so he gave the example, if you were to fire a man because he dates men, but you wouldn't fire a woman because she dates men, the difference between the 2 employees is their sex. And so it's impermissible discrimination. And similar reasoning applies to gender identity. And so I think it's good to take a second to celebrate this outcome. It's a big ruling for our LGBTQ allies in these issues. And so when we're looking at this decision, even though it's about Title VII, which is federal employment discrimination law, the reasoning seems like it could apply to other laws that also protect against sex-based discrimination, and potentially even including the Equal Protection Clause of the 14th Amendment to the Constitution, which has now long protected against discrimination on the basis of sex, but hasn't been interpreted by the Supreme Court to extend to sexual orientation or gender identity. So this Title VII ruling kind of sets up that as a next step of extending the Equal Protection Clause. And to connect it to our work, there's been no mention of religion so far in this summary. When the Supreme Court took the case, it didn't grant review of the question, is there a right to a religious exception to Title VII? One of the cases, one of the 3 that was decided altogether by the Supreme Court was EEOC versus Harris Funeral Homes. And when that case was in the Court of Appeals, the funeral home, which had fired Amy Stevens, an employee Amy Stevens, after she notified the organization that she wanted to follow the women's dress code at work to sort of, live according to her gender identity. She was fired, and one of the defenses that the funeral home raised was under the Religious Freedom Restoration Act, RFRA. And Americans United authored an amicus brief when the case was at the Sixth Circuit, and the Sixth Circuit rejected that defense, saying that the statute didn't create a right to discriminate on the basis of gender identity. And so, like I said, the Supreme Court didn't take up that question, but it did say explicitly in the majority opinion, Justice Gorsuch listed the 3 possible religious exceptions to the new Title VII rule that the opinion announced. And so this sets it up as the next major battlefront in anti-discrimination law, especially Title VII, gender identity and sexual orientation discrimination. And so the three, I'll just run through them quickly, is Title VII itself has religious exceptions built in for institutions whose purpose and character are, quote, primarily religious. So expect litigation over which institutions qualify as primarily religious, what sorts of religious preferences are allowed. It's not, it hasn't been decided by the Supreme Court whether you can say, well, I'm a religious institution and my religion says I have to discriminate and therefore I can't hire gay people, people of other races, what have you. The second exception to the Title VII rule would be the ministerial exception, which Alex is going to speak about next. But just to put it simply, if someone is a minister, they are exempt from all anti-discrimination laws. So there's going to be litigation over who counts as a minister. And then the third is RFRA itself, which, as Justice Gorsuch put it, is a super statute. It creates religious exemptions to all federal law as long as the claimant, the plaintiff, can show that the religion is substantially burdened by government action. And so all three of those could or do present religious challenges to the new anti-discrimination rule announced in the Title VII cases. And that will put AU and our allies right in the middle of that new front of litigation, because that's where the action is going to be next. And I'll hand it over to Alex now.
Thanks, Patrick. As Patrick mentioned, the next case I'd like to discuss, the Supreme Court is going to be clarifying a rule called the ministerial exception. So let me first provide some background on what that is. In 2012, the Supreme Court announced this rule. It's a judge-made rule that essentially provides that it would be an unconstitutional governmental interference into religion if the government played any role in a religious organization's hiring or firing of its ministers. And here, when I use the word minister, I mean, that's the court's language, but really you're talking about people who are articulating the religious principles. It could be a priest, it could be a rabbi, etc. So what this means is that if a court determines that an employee of a religious organization falls within the ministerial exception, employment laws do not apply to that employer-employee relationship. So think Title VII of the Civil Rights Act, think the Americans with Disabilities Act, the Fair Labor Standards Act. The reasoning here is that the court reasoned in 2012 that that the separation of government and religion articulated in religion clauses prevents the government from playing any role in picking who gets to speak on behalf of a religious body. So the core case here you might think would be like a church and a priest, but operationally this tends to arise most commonly with religious schools and teachers. The employer tending to claim that the teacher's job is to pass on the religion to the students, and that therefore they should count as a minister, and therefore the employment regulations can't be applied to that employer-employee relationship. So there are two cases that have been consolidated before the Supreme Court now. One is Our Lady of Guadalupe School v. Morrissey Baru, and the other is St. James School v. Beale. and they're similar. They both present the question of how courts decide whether an employee's job falls within this ministerial exception. So in the Beal case, the plaintiff was a lay fifth grade teacher at a Catholic school. Her duties included some small amount of religious instruction per day, and she was not renewed as a teacher after she informed the school that she would be needed to miss time because she had been diagnosed with cancer. So she's attempting to bring an Americans with Disabilities Act claim. School is claiming that law doesn't apply because of the ministerial exception. The second case, it's a lay sixth grade teacher. Her duties did include some amount of teaching religious curriculum from a workbook. She was demoted, she claims, because of her age. And so this is a case arising under the ADEA, the Age Discrimination and Employment Act. So the first thing to note here is that neither of these schools had a religious reason for firing either employee. And that's the first big takeaway from how the ministerial exception works. If a court finds that an employee falls under this exception, it's lawsuit's over. There's no more inquiry into the reasoning for the employment action that's been challenged. So it's very important. The 2012 decision did not really set a precise test for how to determine whether an employee is a minister, and that is what's going to be determined by these cases. In terms of AU's involvement, we filed a brief, we joined an amicus brief arguing for a narrow interpretation of the definition of minister in these cases, and also arguing for a functional test where courts should look at the totality of the circumstances in the employer-employee relationship. The other side wants a very broad definition of minister, and their preferred test is one in which it's very simple. If the employee's duties included inherently religious duties, then they count. That's the preferred test of the plaintiffs. And the reason why the test is important is that if the test is very formal and mechanical, that could create an incentive for employers to tailor their employees' job duties so as to sweep everyone into this exception that really should be quite narrow. So you could imagine, in an extreme case, a religious school deciding that, well, from now on, all of our employees will rotate through leading prayers before our devotional assemblies, and everyone who leads prayer is involved in, teaching the religion, and therefore everyone's a minister. And, hence, when we fire the custodian for trying to unionize, there's no action available because it's the ministerial exception. That's an extreme example, but this could, depending on how the court articulates the rule here, you could get some extreme results. Some other potential implications here and reasons to watch these cases are this is not necessarily limited to schools. That's, as I said, where it has arisen most often is private religious schools, but in theory, this could be used by nonprofit religious organizations, charities, conceivably even a for-profit religious closely held corporation like we saw in the Hobby Lobby case. So if the court articulates a very broad test here, you could see a big hole being created in a lot of important employment law protections for workers. The other thing to note is that this exception is not necessarily limited to employment law. I mean, it's important enough even if it were, but you could imagine employers trying to exempt breach of contract actions, potentially even tort actions for workplace injuries that occur, saying that the entire relationship between the employer and employee is basically can't be reviewed by a court because it's inherently a matter of ecclesiastical organization and autonomy. So I think this is a really important case to watch. It could have really big impacts on the protections that a lot of workers depend on in a big chunk of the economy, conceivably. So this is a decision we could see at any time. It's been fully briefed and argued, so it's one to keep an eye out on. And I think I'll pass it back to Patrick.
Okay, so another case that the Supreme Court has heard argument in, and we're waiting for a decision in, is Trump versus Pennsylvania, or I think it might have been renamed to Little Sisters of the Poor versus Pennsylvania. And this is another case in the never-ending battle against the ACA and the Obama administration regulation that required insurance plans to cover contraception for employees, workplace insurance plans. So to simplify greatly the history of this, from the Obama administration, there was a rule that certain organizations with religious objections to providing coverage for contraceptives could register their objection either with the government or with the insurance company, the plan administrator, and some other party would step in to make sure that the employees received the coverage for contraception that the law entitled them to. The Trump administration, in an effort to roll that back, has cited RFRA and the Free Exercise Clause and some other statutes in the federal code to say that the government doesn't want to burden the religious beliefs of employers. And so they're creating basically an opt-out that says if you have an objection to even notifying the government or the insurance plan administrator of your objection, then you don't have to. You can just deny coverage for contraceptives, and we're not going to ask any questions. That's religious objection or what they're calling a moral objection. It's sort of unclear what that means. And the ultimate effect is that employers can impose their religious beliefs on employees, and it shifts the burden of finding coverage for contraceptives to the employees themselves. And the point of the ACA rule was to not have that happen, to provide it to the employees, to reduce the barriers to getting coverage and to getting contraceptives. And so the questions here are, one, since the government is citing, since the government is citing RFRA as a basis for creating this mass religious exception for anyone who wants it, does the law actually authorize that? We've understood, and the courts have understood RFRA to be used on an individual basis so far, where a person who is having a law enforced against them can go to a court and say, this substantially burdens my religious exercise, and the government doesn't have a sufficient justification for doing it. And then the court adjudicates that single case to say, yes or no, this person is entitled to an exemption under RFRA. But what the government is trying to do here is just writing a blanket exception for anyone who claims it. So it's short-circuiting the individualized process, and it's undermining the rigorous legal standards that were written into the law. So it doesn't require individualized showings of substantial burdens on religious exercise, and it doesn't allow for a court to consider if the government's interest in requiring coverage for contraceptives, if it's justified. So that's one question. Another question is, does the Establishment Clause forbid this kind of a religious exception? Because what Americans United says, and our partners in litigation say, is that if you look at the Establishment Clause case law, you can't use religious justifications to impose harms or burdens or costs on other people. And what would happen here is you'd be imposing an additional cost on employees who are being denied coverage for contraceptives. They have to find it themselves, maybe have to pay out of pocket. And Justice Ginsburg, in oral argument, really focused in on this legal question: is that how can you use RFRA to harm countless women and people who need contraception? This specific question about third-party harms came up in the Hobby Lobby case from several years ago, where actually every justice either wrote or joined an opinion sort of acknowledging that there was some limit on religious exceptions, that there comes a point where it's too burdensome on other people. And so that question could be addressed here. Those are the two main religious questions. They are important. If the court rules in favor of the Trump administration in this case, it could end up rewriting the requirements of RFRA to remove the individualized inquiry requirement, and it could rewrite the limits of the Establishment Clause to remove the understanding that religious exemptions are limited by the sort of do no harm principle, that you can't harm third parties. So both of those are on the line, and they would have reverberations through all of our work if either of those things were to happen. But it's also possible that the court avoids those tricky religious questions and kind of just decides the case on narrow procedural grounds, which, if that happens, we'll have to see what impact it would really have on our work.
Thanks. The next case I'd like to discuss is Espinoza v. Montana Department of Revenue. And the top line in this case is basically, does the Constitution require states to fund private religious education if they're funding private non-religious education? So Montana has a provision in its state constitution that prohibits public funds from being used to fund religious activity directly or indirectly. It's called a no aid clause. And there's no exact analogy for this in the federal constitution, but it's actually something that you find in most state constitutions, I think 36 of them. So it's quite common among state constitutions. And in 2018, the Montana Supreme Court struck down a private school voucher program. That program was funding private schools, both religious and secular, and the Montana Supreme Court held that that was forbidden by Montana's no aid clause. The plaintiffs have brought this to the US Supreme Court, and they argue that that decision essentially was discrimination against religion, and that the federal Constitution required the state to fund private religious education on the same basis that it funded private non-religious education. This would be quite unprecedented. The Supreme Court has never held that there's a requirement to fund religious education. The plaintiffs have relied heavily on a decision that the court made a few years ago called Trinity Lutheran, but that case turned on a state law that excluded a religious, it happened to be a religious preschool from a generally applicable government program that had no connection to religion. It was a program that provided for resurfacing of playgrounds. And the state had excluded the school from participating. The Supreme Court held that the school could not be excluded from that non-religious program purely on the basis of its religious identity. This is a very different case because we're talking about funding religious activities. We're talking about funding religious education. And it would be unprecedented for the court to hold that it is compulsory for a state to fund that type of education, particularly when that state has a longstanding constitutional provision prohibiting that in its state constitution. So we, in Americans United, filed a brief joined by many partner organizations arguing that that the Constitution does not require this. In fact, it's forbidden by the Montana State Constitution in a provision in the No Aid Clause, which has a longstanding history and is vindicates traditional anti-establishment interests. So the implications here, I mean, if the Supreme Court holds that if the Supreme Court reverses the Montana court's decision, it would drastically change the landscape of funding for private schools. It's possible that a holding could even go beyond education and implicate all sorts of government programs where the government provides funding for only secular activities based on its valid anti-establishment interests. And so this would have a really big impact on our work. It's also important to note that many of these schools that were potentially receiving voucher funding in this program had discriminatory policies, particularly discrimination against LGBT students, and that this would also be a very dangerous precedent in terms of allowing compulsory public funding of discrimination, which also should not be allowed under the Constitution. One final thing to note about this case is that there is a third possibility here in which the court could avoid ruling in either direction. Because the Montana court struck down the program in 2018, there is no program right now, and so arguably no one is being harmed because neither secular nor religious schools are receiving any voucher funding right now. So there's no discrimination and there's not really a live controversy. It would be highly unusual for the Supreme Court to order the program to be reinstated years after it was taken off the books. So it's possible that this ruling may end up being decided on what's basically a procedural ground rather than on the substance of the controversy. So that's something to keep an eye on too. But this case, if it turns out the other way, it will have a big impact on the operation of no-aid clauses. And as I mentioned, they are important parts of the constitutions of majority of states in the country. So it would have a big impact on our work. So I should also note, this is actually the oldest case the court has right now for which they have not issued an opinion. So it's quite likely for this to be decided very soon. It could be decided as early as next week. So it's definitely one to keep an eye on and to expect a ruling in soon. So turn it back to Patrick.
Thanks. I think we have a few minutes, so I'll try to run through quickly a case that has it presents a big question to the Supreme Court, but it's not one where we'll have a decision anytime soon. So the case is called Fulton versus City of Philadelphia. In that case, the City of Philadelphia has a law that says the city and its contractors can't discriminate against people for sexual orientation and gender identity. And pursuant to that law, the city refused to renew a contract that it had with a Catholic social services organization involved in placing children with foster parents, I believe. And the city cited that rule, saying as long as you won't provide services to same-sex couples and the like, then we can't contract with you. And the social services sued the city to say that they felt they were being forced to violate their religious beliefs, and that the city was discriminating against them because of their religion. And this has echoes of the case that Alex just talked about, where the religious group is essentially saying that they have a right to a government contract, to government funding, regardless of neutral rules. Neutral meaning not religiously discriminatory. It's just a rule against discrimination. And the social services organization says that they should be exempt from that, and also should receive a contract from the city. So the Supreme Court has taken that case, and the big question that it's considering is if it should overrule a case from 1990 called Employment Division versus Smith. And that has been the linchpin of modern free exercise doctrine in the courts. And it says, it stands for the rule that if the government passes a neutral and generally applicable law, meaning that it doesn't target religious people or religious practices for discriminatory treatment, then even if it incidentally burdens someone's religious exercise, there's no constitutional problem with that. And the idea, this was written by Justice Scalia, and as he explained it, you can't really have a functioning society if every single person gets to decide for themselves which laws to follow, which laws not to follow based on their religious beliefs. And now this was a controversial opinion at the time. People still have very complicated feelings about it, but that has been the law for 30 years now. And the Supreme Court could overrule it. They could create a rule that sounds more like the standard created by RFRA as a statutory rule, that if your religion is burdened, then the government has to have a very persuasive justification for it, or else you get to have an exemption. we don't really know, but that's the question being presented. And if the Supreme Court rules in favor of the Catholic Social Services Organization, that would upend the law, the constitutional law of the free exercise clause, and that could really disrupt our litigation if that happens.
Yeah, Patrick, you almost started to answer one of the first questions in the Q&A, which I think is a really great one. I'd love to hear from both of you on this. The question is really, what are you most worried about as two attorneys who spend day in and day out in the cases, both at the Supreme Court, or maybe cases that are working their way through lower courts, or maybe just shifts you're seeing in principles coming out of the courts? What are you most worried about around separation of religion and government and cases? And then also, what's giving you the most hope?
Yeah, I think, as Patrick was just mentioning, a change in the Smith standard would probably be among the top, if not the top, concern. The Smith standard is really, it's a critical one in our work, and so for instance, it really would have ramifications everywhere at both the state and federal level for a heightened standard of review to apply to free exercise claims. We've seen a lot of kind of sort of misuse of RFRA in a lot of contexts. The Hobby Lobby case being a good example of a corporation claiming that RFRA entitled them to an exemption from providing contraceptive coverage to employees. If Smith were to be overruled, they would have a better chance of making that a constitutional claim, which would be even harder to fight back against. There is increasing kind of a push to get the court to reevaluate that. I mean, there's both the case Patrick was talking about, and there's another case that's, there's a petition for certiorari pending, Ricks versus Idaho, I think. So a lot of people on the other side have been kind of agitating for this, and we'll see what the Supreme Court does with it this term. I don't know if, Patrick, you have anything to add to that?
Yeah, well, something that hasn't come up in the cases we've talked about yet, but well, I guess I sort of mentioned it in the Title VII discussion maybe. Something that I'm worried about in the future is the direct clash between religious freedom and anti-discrimination law. The Supreme Court had a chance to answer that in Masterpiece Cake Shop a couple years ago and didn't really. And so now, you know, the Title VII opinion kind of teed it up again. There's another cert petition pending with the court in a case called Arlene's Flowers, which is basically Masterpiece Cake Shop 2.0. It's a florist who wouldn't provide flowers for a same-sex couple's wedding. And so that's going to be either under RFRA, or even if the free exercise clause is reimagined by the conservative justices, you're still going to have that clash. And at some point, the Supreme Court is going to have to decide whether, fighting discrimination is a sufficiently important government interest that it outweighs the, alleged religious freedom interest in discriminating.
What about that hope side, Alex? Is there anything either in the courts or in social movements that's giving you hope as an expert, a legal expert on these issues day in and day out?
Well, the Title VII case certainly shows that we can still win at the Supreme Court level. There was another outcome recently at the Supreme Court. It was not a full case, but AU was very heavily involved in wave of litigation that arose out of the COVID-19 public health orders. There was a lot of religious challenges in many states claiming that those public health orders couldn't be applied to religious gatherings. And they rocketed it up because they were emergency cases seeking emergency relief. They went up to, if they lost in the district, they'd go up to the circuit, and then one of them went up to the Supreme Court. Again, not as a case on certiorari, but as a request for emergency relief. And in a 5-4 decision, well, not decision, but the court rejected the request for relief. 5-4, Justice Roberts wrote a concurrence that sounded a lot like a lot of the briefs we filed, and really we think his reasoning really aligned with our opinion on those cases. So I guess that's both a hope and a worry, because it shows again that we can still win, but it's any change in the court's makeup would potentially move Roberts out of that pivotal role in which he sometimes rules on our side and sometimes doesn't. But you could imagine that fifth justice being someone who very rarely moves on our side. So I brought it back to a worry.
And sort of staying on that topic of COVID-19 response, we've had a few questions. I'm going to tee it up for you a little bit about the PPP, which is the Paycheck Protection Program. So this is an aspect of one of the stimulus packages related to the COVID response that said, hey, businesses and nonprofits, if you keep all of your current staff employed for a certain period of time, we'll give you a loan to cover those salaries. And in some cases, those loans might convert to grants, meaning you don't have to pay them back. And when that section was written, it was silent on the issue of whether or not that funding could be used for clergy salaries. So long story short, that sort of sets us up for a scenario where potentially what will happen, or what we'll learn has happened, is that government funding has been used as a direct grant, so not a loan that's repaid, but direct funding of clergy salaries, potentially the salaries of worship leaders. So AU has been really active in this space. We have been, our professional lobbyists on Capitol Hill have been lobbying the Small Business Administration and members of Congress on this issue. We are also very closely monitoring the data release that's going to be forthcoming. Just last week, the Trump administration said, well, we'll give you some of that data after a little bit of a protracted political battle. So we'll be analyzing that data very closely to understand where the funding was or wasn't, where did it go. But I think the question I'd like to pose to you, Alex and Patrick, is more about what are the legal issues that potentially exist there, and what might various organizations be thinking about as they question like litigation. I guess the question I'm really asking here is someone going to sue? Is there grounds to sue? Is the court a question? And when we think about suing, to just like really maybe unpack what legal issues or what factors go into parsing that as the data is available and folks begin to really look at that program and how it was executed.
I'll take a stab at it, and then Alex might have something to add. Something I learned early in my time at AU is that going back to the founding, if you read the history behind the Establishment Clause, one of the main concerns at the time was forcing people through taxes to pay for the salaries of ministers. Basically, they thought it was an infringement of religious freedom to force anyone to subsidize religious exercise, religious education, religious dissemination. So if you take that principle and carry it forward, it seems like the PPP funding clergy salaries violates that rule. Now, we've talked a little bit about the Trinity Lutheran decision from a few years back that said you can't discriminate against religious entities because of their religious identity. but that dealt with playground surfacing. And this is a much more religious, it's the most religious use of taxpayer money, which is to pay clergy for their services. So I think there's great reason to believe that the way it's been administered violates the Establishment Clause. But I also think there's reason to be skeptical if we would have the Supreme Court on our side, since the 5 conservative justices plus Justices Kagan and Breyer, actually, in Trinity Lutheran, all said you can't discriminate against the church because it's a church. So, you know, I think you might see litigation, but I would be cautious.
Yeah. Thank you. Do you want to add there, Alex?
I'd just add, I mean, as I mentioned talking about Espinoza, I mean, there's a reason why 36 states have no aid clauses in their constitution. I mean, this used to be something that was a firmly widely accepted principle that that separation of religion and government meant no funding for religion, and that was good for both government and religion. There are challenges to bringing a lawsuit like this, both in terms of the caution Patrick was mentioning that you wouldn't want to. There are challenges logistically in terms of getting the data, finding out who actually got the money, finding, the ideal plaintiff who would be in the position to challenge it. And there's also the worry that given how Trinity Lutheran turned out, now you're adding a case where there's also kind of an economic catastrophe that sort of might make the other side look even more sympathetic than they would during normal times. So all of this is, not necessarily reason to not sue, but reason to be cautious about doing it, I think.
Thank you, both of you. I think, one of the things I have learned working for organizations that do this incredibly important civil rights and civil liberties and constitutional litigation is the many complex factors that go into bringing these cases, knowing that they might go all the way to the Supreme Court. So I'm hearing you say, we're still waiting on data. We're still looking to understand, we sort of collectively as a country, and that also we're really going to be paying attention to what the court says in cases like Espinoza and the ministerial exception to really understand where this court is on some of these core issues that will be at issue as we learn more about the PPP program and how it is or was executed. So thank you for sort of explaining some of those complexities. I'm going to do one more question, which I think is a really wonderful question from our friend Helen, which is about contraceptive access. So pivoting to that case where we're still waiting for the Supreme Court to rule. And Helen asks, so doesn't the Establishment Clause prevent privileging one religion over others? So why doesn't the Establishment Clause prevent a religious exemption that allows a religion to forbid contraception? Sort of, isn't that privileging a religion? How do we balance the sort of needs, whether they're religious or public health needs of a patient versus a provider, really kind of grappling with, is it unconstitutionally privileging a religion to say you can have an exception to the contraceptive mandate?
I'll go first, I guess. So the Supreme Court has said that there is play in the joints between the Establishment Clause and the Free Exercise Clause. So the First Amendment, it forbids religious preferences, but it also does explicitly protect religious exercise. And so the Supreme Court has said there's kind of a room in between to accommodate religion, to make their lives easier, and this, it fosters religious belief, which is important to many millions of people in the country. But the important part from our perspective at AU is that the Establishment Clause is like a backstop against it. So if you can give these reasonable accommodations that remove government burden from religious exercise up until the point that it starts to affect other people in a negative way, and so we're very active in the courts to remind judges that the Establishment Clause is there as a limiting principle on accommodating religious exercise.
Thanks, Patrick. I have one time heard our executive, Rachel, say, your free exercise swing ends at the tip of my nose. This concept that you just articulated, that the Establishment Clause is about being a shield to protect, not a sword to harm others. And so it sounds like that's really sort of at play in this case. And what those who oppose AU's position are sort of trying to assert is the use of religious freedom as a sword and not as the shield as it was, we would argue, intended. So we are at the end of our hour, which is remarkable. That went fast. I always love listening to lawyers talk and really getting down into the details. And I want to thank you both for your time and thank all of those who joined us today for your time. I hope you'll join us one more time next week. We're going to round out our summer series with college students, AU summer interns, who will be discussing the intersection of religious freedom, school vouchers, and disability justice, and really raising some important questions about how AU and the work that we do impacts people in this country living with disabilities, particularly young people and public school students. So thank you so much. We hope you have a wonderful day, and we'll see you next Tuesday at 3 p.m. East Coast, 12 p.m. West. Thank you, Alex. Thank you, Patrick.
Thank you.